the AMA stands for Appeals Modernization Act. Can you give a brief overview of it and sort of its main objectives?
Sure, and it's interesting that the VA refers to this as the AMA. The actual title is the Appeals Modernization and Improvement Act, and somehow they managed to leave out the improvement part. But what the act is all about, Congress got fed up with constant complaints about the VA disability system. Every senator, every congressman's office got complaints and more complaints about how poorly the VA disability system works. And that's for a lot of factors that we can talk about, but the result was that Congress pressured the VA to try to develop a better system for handling its cases.
Welcome to the Victory Over VA podcast, a podcast about empowering veterans to overcome denied disability claims. Each week, we deliver critical insights to help you understand the disability process, veterans' benefits, and how to take control of your legal rights. Now here's your host, Attorney Francis Jackson.
Hello, welcome to Victory Over VA, your guide to unlocking your disability benefits. If you're a veteran applying for benefits, subscribe and listen to the latest developments in VA disability. So welcome, I'm Francis Jackson, this is Christian Terrison. We're with Jackson and MacNichol, a law firm that specializes in getting justice for VA claimants, veterans who are seeking VA disability benefits. Now, what's this about? Well, today we are going to talk about the 2019 change in the law, what's called the AMA. And so who is this for? Well, it's obviously for veterans, but more importantly, it's for those who care about veterans. It's for folks who are friends or relatives or just in the community wanting to support our veterans. It's for all of those folks to help understand what's going on in these VA cases and how to help.
All right. So the AMA stands for Appeals Modernization Act. Can you give a brief overview of it and sort of its main objectives?
Sure. And it's interesting that the VA refers to this as the AMA. The actual title is the Appeals Modernization and Improvement Act. And somehow they managed to leave out the improvement part. But what the act is all about, Congress got fed up with constant complaints about the VA disability system. Every senator, every congressman's office got complaints and more complaints about how poorly the VA disability system works. And that's for a lot of factors that we can talk about, but the result was that Congress pressured the VA to try to develop a better system for handling its cases, and more specifically, for handling appeals. So remember, the VA system works like this. You make a claim, which now has to be on a VA-approved form. Once you make that claim, the regional office in the area where you are, or sometimes in another area even, but a regional office, makes a decision about the claim. And that usually takes somewhere from 30 days to 6 or 8 months, depending on the complexity of the claim and how busy they are and lots of other factors. Once that initial decision is made, that's really where the AMA comes into play. The AMA says, okay, once you have an initial decision and you're not happy with it, you have 3 different choices. And this is very different from the previous system. In the previous system, if you weren't happy with the decision, you had 2 choices. You could reapply or you could appeal. But under the AMA, you now have multiple choices. You can always reapply. That's a process that the VA has now characterized as filing a supplemental claim, meaning a new claim on the same condition that's already been denied. And the change in the AMA is that in the old system, you just went back to the VA and said, hey, you turned me down for my left leg, I want to reapply. And they would go through the entire process with you again, looking at the claim. Now, typically, they would come to the same result as the previous time, but regardless, they would go through the whole process. Now, you have to file a specific form the 0995 form, it has to say that you're making a supplemental claim about a previously denied claim, and you have to provide what's called new and relevant evidence, meaning that if you got turned down on your left leg before, now you have to come back to the VA with some new medical evidence relating to that left leg that will help them to understand why the prior decision was wrong. You can't just say, I want you to look at it again. It doesn't really work like that. You have to bring new evidence. So that's one possibility under the AMA. A second possibility under the AMA, instead of the supplemental claim, is to ask for what's called higher level review. In higher level review, the VA takes exactly the same information they had before, but they provide it to a more senior person, someone with more experience within the VA system. And the object is to have a more senior, more experienced person look over what the original decision said and make sure it's correct. Now, HLR doesn't very frequently help in the sense that most of the time, HLR claims are denied. The VA essentially says, we turned you down. Yes, we've looked at it. We got it right. You're turned down. Not very helpful. But there are times when the VA makes a particular technical mistake or misses a critical fact, and that can be pointed out on HLR. And once in a while, you get a different decision. I mean, it's not a completely useless process, but it's not one that has a high probability of success. The good thing about HLR is that it is relatively quick. Typically, those cases get resolved within 6 months to a year, and that's faster than an appeal. Now, the third process we're talking about here is, in fact, an appeal. It's kind of the same process that used to exist before the AMA went into effect in February of 2019. And it is, you file a notice of disagreement, and your case is then put in line for review by the Board of Veterans' Appeals in Washington. The bad news is that it's a pretty slow process. They're currently processing claims that were filed in 2019. And we're in 2023. But the good news is that one of the reasons they're slow is that they're quite thorough. The board is staffed by judges, all have a legal background, of course, and it is supported by other attorneys, staff attorneys, who work for the judge and who are charged with pulling together all the facts, making sure that the judge has all the information about the facts and the law to make the best possible decision. So what you know is that, number one, your claim is going to get more consideration than it did at the regional office. It's going to be looked at by more sophisticated, more skilled people than the folks who saw it at the regional office. And generally speaking, difficult cases pretty much have to go to the board. It is unlikely that even if you do supplemental claims over and over, which you can, that you're going to get anywhere at the regional office with a tough case. Those typically have to go to the board. Now, the other refinement on the whole board process that the AMA has brought is that the board process always used to be the same. You applied to the board and you got your case sent through, and typically you would have a hearing with the judge, either an in-person hearing, the judge would come to the regional office, or a video hearing where you would go to the regional office and the judge would be on video to the central office in Washington, D.C. What's happened now is that the AMA has split the board process into three kind of what they call lanes. One is you simply ask the board to look at what's already in the file. You tell them, you've got all the information, you decide it based on what's here. Not surprisingly, most of those are denied. The second option is to file an appeal to the board and to supply new evidence. Like the discussion about the supplemental claims, it requires new and relevant evidence, meaning if you were turned down because there was no medical opinion explaining how the injury to your ankle in the service has resulted in the necessity for ankle surgery now, then you have to come back with information that ties that together, typically a medical opinion from a doctor, nurse, chiropractor, someone who has a medical background and can explain to the board why it is that what happened to you in the service, whatever it was, is now connected to your current medical condition, whatever that is. You have to have that link. They call it a nexus. And we have an internal process for using these nexus cases that we've actually submitted for trademarking because we think we do a very good job with it. But coming back to the point, the AMA gives you these three options: direct review, evidence submission, and the third one is pretty much what was typical of the board before. You get an actual hearing, either in person or virtually, primarily virtually, with a board judge, and that judge will hear what you have to say and put that information into the VA's system, and then either that judge or more likely a different judge will make a decision on your case. And sadly, that last piece has really reduced the usefulness of having a hearing, because the point of having a hearing was for the judge to see you and hear you and be able to evaluate what you were saying and have your opportunity to tell your case to the person who was going to decide it. With the AMA, they've changed it so that frequently the judge who decides your case will not be the judge who actually heard the hearing and made the notes. So the new judge who's making the decision is working off what was in the record and the notes that the judge made at the hearing. And it's like any other situation where information is relayed from one person to another. Not everything carries over. So the value of hearings in the AMA, in my opinion, has been reduced. But it's still your opportunity, the only opportunity for a veteran to actually tell his story, or her story as the case may be, to the folks who are ultimately going to be deciding it, even if it's not the actual person who's going to put their name on the decision.
So you've talked a little bit about the lanes and the comparative differences. For a veteran going to the board, how might they decide which lane to choose?
Well, direct review is kind of like HLR, higher level review. It really is just bringing the same information to hopefully a more sophisticated decision maker. So unless you have a situation where the VA just got it totally wrong in their decision, my personal view is that direct review is pretty useless. You know, there has to be something really glaringly wrong with the original decision for direct review to be of much help. The other lanes are harder to separate. If you are one of those veterans who still has a pre-February 19 decision that's being fought about, what's called now a legacy decision, meaning left over from the pre-AMA decision, in my view, you should definitely go for hearing. In those cases, the judge who hears the hearing will also be the judge making the decision. I think that's often very important and very helpful, and you should definitely go for the hearing. If you have a decision from February 19th, 2019 forward, it means that the judge who hears the case may well not be the judge who decides the case. You have a chance that the judge hearing it will decide it, but there's no guarantee. That makes the hearing process less useful, in my opinion. I think you get less bang for your buck if you don't get a chance to talk to the person who's actually going to make the ultimate decision. But the utility of the hearing process is that you still get to offer new evidence. And so you have to choose between the evidence review lane and the hearing lane. In the evidence review lane, the trick is that the time period to get the information is shorter. From the time you file your notice of disagreement, you have 90 days to get all of your information together and submit it to the board if you go in the evidence lane. If you go in the hearing lane, you have the entire period from the time you file the notice of disagreement up until you have your hearing at the board, plus an additional 90-day period after the board. Now, one thing that trips a lot of people up and that you have to keep in mind is that in cases where you have other things pending that may ultimately lead to a higher likelihood that the board will approve this particular claim, then you may want that longer period. And the part that trips people up, though, is that say you have a decision in 2023 and the board's not going to hear your case until 2026, and in the meantime, there are a couple of favorable decisions from the regional office that would help with this claim that the board is going to hear in 2026. The board's not going to consider that unless you take that information, those decisions or whatever other favorable things came along, a favorable compensation pension exam, whatever, and you take that information that's now already in the VA's file and resubmit it in the 90-day window after the hearing. And that makes no sense, but that's how the law is being interpreted by the VA. And so they will literally ignore favorable evidence that came into the file after the date of the decision and before the board hearing, unless you carefully copy it all and resubmit it to them, which is, let me just say, I don't think it's a very smart way to operate. But regardless, that's how it works. And that's a problem that trips people up on a regular basis. They think, oh, well, my decision was 4 years ago and I'm having my board hearing and all these wonderful things have happened in between and that's all in my file. Well, it is all in your file, but the board's not going to consider it at all unless you resubmit it, which is, I think, just not a very efficient process, to put it mildly. But that's how it works.
All right. Now, for the million-dollar question, what impacts have you observed on the speed and efficiency of the appeals process since the AMA came into effect?
That's a really loaded question because it goes down two different paths. The VA has a process where a claim can be what they call advanced on the docket. If you're 75 or older, or you have a potentially fatal medical condition, or you've been forced into bankruptcy, you're homeless, there are certain things that the VA will take into account and move your case ahead of other people's cases. So if you're in the advanced on the docket category, then the process actually is moving relatively quickly for VA. You probably will get a hearing and a decision within 2 years of your notice of disagreement if you were advanced on the docket. Unfortunately, that pushes everyone else back. So if the board is tied up doing cases that are advanced on the docket, the poor person who's just an ordinary person, 70 years old, not bankrupt, scraping by on Social Security and what his younger wife may be making, or some other combination of financial circumstances. That person gets his case pushed back and back and back, and right now it's taking 4 years for those cases to get decided under AMA, or to get heard under AMA, and then another year or two in some cases for them to be decided after they've been heard, which frankly is absurd and ridiculous. And even the VA acknowledges that's not good. And they've hired a bunch of new judges, they've hired a bunch of new lawyers. They're doing what they can to expedite the process. But the problem is, it's a very slow process. And the way they do it makes it even slower. So the short version, in my opinion, is that unless you have a case that you can win on a supplemental claim or higher level review, and unfortunately, neither of those categories result in very many favorable decisions. Unless you can do that, I think the AMA is as bad and possibly worse than the way things were progressing prior to the AMA. But that's not entirely the fault of the AMA or the fault of the VA. What has happened is that there have been some changes in eligibility. The most common one is the so-called PACT Act, which is a new law that came out under President Biden, effective a little over a year ago. And in that law, the VA greatly expanded the conditions that they would presume to be service-connected. And the way VA works, for a service-connected condition, you have to show, number one, something that happened in the service. Number two, a current medical condition. And number three, a medical nexus or link between those two. What a presumption does is to say, if you have the condition and you served at a certain time and place under certain circumstances, we will automatically assume the medical connection. So, for example, prior to the AMA, if you had hypertension and you served in Vietnam or in the waters off the coast of Vietnam, you had to prove by medical evidence that your exposure to Agent Orange in Vietnam resulted in your current hypertension. You had to have a medical opinion showing that. Under the PACT Act, it is presumed that if you have hypertension and you served in Vietnam and were exposed to Agent Orange, that the hypertension is a service-connected condition that arose from your exposure to the Agent Orange while you were in Vietnam. And the result is that a much larger number of veterans are potentially eligible for benefits. The VA has already received several 100,000 new claims as a result of the PACT Act. So the combination of new eligibility together with the VA's already overloaded system has resulted in this system where, unless you're advanced on the docket, appeals to the board are very slow. They're just very slow. And when we have to appeal a case to the board, we tell people it's very slow because it's very slow. But it is also the best path to getting the best result, even though it's slow. So you can have a situation where, and I've heard people say this so many times, veterans will get advice, oh, don't appeal, it takes too long, just reapply. Well, if you just reapply, you mostly just get denied all over again. And to break out of that cycle in complicated or difficult cases, you're going to have to go to the board, and you might as well just do that in the beginning instead of waiting to get denied 2 or 3 more times and then going to the board. But people have an aversion to waiting a long time for the decision, which is reasonable and understandable. And so lots of folks are reluctant to go to the board, even though it's a case that is only going to be granted at the board. They keep hoping that something magical is going to happen and it's going to get granted at the regional office. Someone once said that the definition of insanity is doing the same thing over and expecting a different result. And unfortunately, that's the kind of magical thinking we see a lot with veterans at the regional office level. Oh, I don't want my case to go up on appeal. It'll take too long. It'll take too long. True, it'll take a long time, but you have a better chance of winning. So, it's a difficult situation, but I don't think the AMA has made any spectacular difference. I think HLR and supplemental claims have peeled off a small percentage of claims that would otherwise have gone to the board. I think direct review and evidence lanes have peeled off a small percentage of cases that would have otherwise gone to hearing. But the trick is the board does these cases in docket order unless they're advanced on the docket. So even if you go in the evidence lane or even the direct review lane, it's not that much faster. And unfortunately, the VA doesn't really publicize that fact very much. They say we take them in docket order, but they don't point out that also means that even if you take one of these other lanes, it's probably not going to go much faster than the hearing lane, and you have more options in the hearing lane. So that's my overview.
All right. Well, and that's actually all the time we have for today. So thank you for tuning in to Victory Over the VA. Please be sure to subscribe and check back next week for more information on the latest in veterans' disability benefits.
Take care, all.
Thanks for joining us this week on the Victory Over VA podcast. Make sure to visit our website, veteransbenefits.com/podcast, where you can subscribe to the show in iTunes, Spotify, or via RSS, so you'll never miss a show. While you're at it, if you found value in this show, we'd appreciate a rating on iTunes, or if you'd simply tell a friend about the show, that would help us out too. If you like this show, you might want to check out our free consultation to see how we can help you with your denied claim. Simply go to veteransbenefits.com and fill out the form. You fought for us. Now let us fight for you. And be sure to tune in next week for our next episode.